I want to talk to you today about the typical court process for an impaired driving or a DUI charge in Canada, and specifically in Ontario. This is an issue which we go over very carefully with our clients. They need to understand the general steps in the file and the typical timelines. That's a very important question that they need. So what happens? You're arrested for a DUI today. They're going to release you likely if you have no prior record, obviously, on a promise to appear or an officer in charge undertaking. Now, that court date is going to be about 3 to 6 weeks down the road. You hire us, what do we do? Well, first of all, we have you sign a designation. That's a court document we file, in which we're your lawyers, and that we appear for you at the first appearance. Immediately, we order the police reports, the disclosure. That's all of the documents we need to analyze your matter. Police statements, witnesses, video statements, you name it, your video of you at the police station. That, once we get those documents, that allows us to provide you with a legal opinion about your case. What are the odds of winning? Can we win this case? Can we get a deal? Would the Crown withdraw it? What are the issues? Usually the Crown, of course, strives to get that to us before the first court appearance. They often don't. If they do, great, we'll review it carefully. That's quite a few hour process, by the way, by the time I analyze the police reports, which could be 60, 80, 90, 100 pages sometimes. Video statements at the police station as well, and video surveillance of you. These are all important documents to receive. We sit down with you, we review that carefully, we receive your version of events. That meeting can take up to a couple hours sometimes, and provide you with a legal opinion. We're going to provide you with a legal opinion of what your basic odds of winning are, whether we think there's any case here, whether we think you should plead guilty. What can we do with your case is the bottom line. That's the key. Once I have the disclosure, once I've met with you, and this may be several meetings, I also want a statement taken from you in detail. I'm in a position to meet with the Crown Attorney pursuant to your instructions. I meet with the Crown Attorney and I say, look, this client's heading to trial. Let's talk about court management time. What deal are you offering? Are you offering to withdraw? Will you offer us a careless driving? We have a fulsome discussion about this. If the Crown offers a deal we like, that's great. We grab it because we've got a pretty good, decent chance of winning. The Crown offers a careless driving, and away we go. We avoid a criminal record, or they withdraw the charge if there's no reasonable prospect of conviction. So those meetings are called Crown pretrials. They can take place at any time after I review the disclosure, and it's just a meeting with me and the Crown discussing your case. So we go to this first appearance. It automatically goes over 12 weeks. That first appearance is just a reporting mechanism where I say to the Justice of the Peace, look, we've been retained. The matter's automatically going over 12 weeks pursuant to the designation, which is just a piece of paper, a document you've signed. And we're expected to do the normal steps in the file in that 12 weeks to move the file along. There may be missing disclosure, which we request in order. The Crown is expected to get that to us. There may be ongoing meetings with you. We report back to you what the Crown said, grab a deal if it's great, or we're heading to trial. Now, if we've got a deal, that can be done. We can move the court date ahead and do it any time. So don't worry that the case has gone on for 12 weeks. That's meaningless because the steps in the file can take place within that 12 weeks. We can also move the court date ahead to either plead guilty to careless driving, plead guilty to the impaired for a deal if you're going that route, or we're heading to trial. If we're heading to trial, after I've had all of my meetings with the Crown to fully discuss all the trial issues, how long the trial is going to take, etc., all the legal issues, all the charter applications that need to be brought, and the Crown saying they won't give us a deal, but we think we have a decent chance of winning. Well, now the next step is to organize what's called a judicial pretrial. That is simply a meeting with a judge. The Crown, myself, and a judge meet, not the trial judge, but an independent judge who won't be doing the trial. We'll be discussing all the trial management issues, the witnesses that are going to be called, the legal issues, the factual issues. The judge might give their opinion about the odds of winning. The judge might prompt the Crown, possibly, look, why don't you offer a deal here? They got a great case, or not. Every judge is different. Some like to intervene a little bit, and others just stay hands off. You got to know your judges, by the way, because it's important to try and find the right judge for the judicial pretrial if you can. Now, Once we've had that judicial pretrial, usually we only need one, sometimes we need two. We're now in a position to set a trial date. Now, how long is that going to take before we're in a position to set a trial date? Well, in Ontario, you're probably looking in the 3 to 5 months range before you're fully prepared to actually set the trial date. You've got to have meetings with the client, the Crown, judicial pretrial, one or more. Now we can set the trial date. We organize the trial date with the trial coordinator, and then we set that in court. What are the timelines for that? Well, it depends on the county. Some counties are very busy and very tied up. Others are not. Smaller counties, they're not that busy. You're going to get a trial date, depending on the county, the earliest possible, and this is really pushing it, might be 6 or 7 months, rarity, up to about 15. Some counties 9 to 12. If you told me a county in Ontario, I could tell you when the trial would approximately be. Of course, the trial is expected to complete within 18 months from the date of your arrest, or there might be a delay application to stay the charges. That's covered in another video. And of course, the trial, say it's 12 months down the road, we're going to vigorously get ready. We're going to prepare. I'm going to prepare you to testify. That's going to take hours. I need to prepare myself for the trial, which is an ongoing process. It takes many hours. And we're there to win. We try and go to trial and cross-examine. We may call you as a witness, and we try and win the case. So the other thing to keep in mind in Ontario is we have what's called Stream A ignition interlock. I covered in another video, of course. In Ontario, currently pursuant to COVID protocols that were brought in, you have 282 days to plead guilty to qualify for Stream A. Some people, there's a limitation period. If you don't plead in that 282 days, you don't get Stream A. I re-encourage you to watch my other video about what Stream A means. Many clients choose to take that if they don't have a winning case or they're not offered a deal, because for them it might be a good solution, Stream A ignition interlock. Normally, the limitation period is 90 days. I'm not sure if they're going to go back to that post-COVID to 90 days because there was always pressure to enter a guilty plea before COVID because you only had 90 days to enter that Stream A. So that's all changed, and I'll have an update on that in the future when we get out of COVID. Maybe they're going to keep the limitation period at 282 days. It'd be actually a good thing if they did. So that, in a nutshell, is what happens for a summary conviction DUI, where we're taking the file right from the start, from the date of the arrest, right through the end of the trial, and if you resolve it in between. One thing to keep in mind, if you decide to resolve your charge, that is plead guilty or get a deal for careless, or hopefully get the charge withdrawn, these court dates can always be moved forward to do that. So we can do that very early on in the process. For example, if we get the disclosure and figure out you don't have a ghost of chance of winning, but let's get the best deal we can with the Crown, well, that court date that went over 12 weeks can be moved forward to do your guilty plea. That, in a nutshell, is the typical court process for a summary conviction DUI in Ontario. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.